Greetings, students, and a very warm welcome to you all in today's session on Indian polity and governance. Today, as part of our continuing lecture series, we are going to take up a very important lecture as far as the Indian Constitution and Indian polity is concerned. The topic which we are going to take up today is basically uh, emergency provisions. That is, what are the different emergency provisions that have been instituted or that our Constitution contains, the reason, the logic behind inserting emergency provisions in the constitution, and apart from that, what are the various types of emergencies that our constitution allows president to declare. And apart from that, we will be also looking at the recent instances, because we know that the presidential rule, or for that matter of fact the constitutional emergency, this has been in news recently in various states, like Jammu and Kashmir has seen the president's rule. In fact, in J&K there are two types of there are two types of emergencies. There is one presidential rule, and then there is also governor's rule, which we call. So there can be either governor's rule or president's rule. So similarly, in recent past, we have seen emergencies or constitutional emergencies being proclaimed in different states. Like Uttarakhand has recently seen the constitutional emergency. Similarly, other states like Arunachal Pradesh, and similar other in there is no year when for one or other reason, for smaller shorter duration, for larger or shorter duration, the constitutional emergency or president's rule is not imposed. Now, what are the grounds of the imposition of the president's rule? And apart from that, what are the grounds of imposition of the national emergency and other type of emergency, that is the financial emergency? All these topics are up for discussion today, and we'll be looking up all these topics today. So before I take up the main discussion, I want you to have a look at these two images. The image on your left side of the screen is basically that of 1975, when the internal emergency was for, the emergency was declared for internal disturbance, which was later on quashed by the by the Supreme Court, and it says, and also by the Parliament. They said that we are going to delete this particular provision, internal disturbance, and instead of internal disturbance, we will use the word armed rebellion, which we'll be taking up later on. Why I have projected this screen? I have projected this screen because because of the fact that the emergency completed its 50 years recently. The imposition of the emergency completed its 50 years recently. So that is why I have brought I have displayed this particular pic. And on the right hand side, you can see the image of Uttarakhand Chief Minister Rawat. And basically what happened was that the president's rule was imposed into Uttarakhand, but later on Supreme Court basically cautioned and said that the grounds of imposition in Uttarakhand were not right, so they cautioned that particular rule. So all these things are up for discussion today. Now let's talk about what are the learning objectives, or what are the takeaways of today's lecture, what you're going to add up to your repository of knowledge at the end of this particular lecture. The first thing which you're going to understand is that what is emergency, right? Why do you require emergency, or what to do in case of emergency, right? Firstly, we'll be discussing what is emergency, what are the different types of emergency, right? There are three grounds of imposition, right? 352, 356, 365, and another one, right? So there are three. This is what constitutional emergency is, right? This is what constitution. This is the national emergency, and then there is financial emergency also. Right, these are the three types of emergency, in fact. Right, now what are the various provisions regarding the emergency? That is what happens during the emergency, how the state how the state basically changes, how federalism, how the federal nature of Indian polity changes, right? What is the impact on finances, what is the impact on executive, what is the impact on legislature, right? All these things will be taken, or all these things will be discussed, and later on we'll also do few MCQs on the on the basically on the emergency. So now let's talk about what emergency is. Basically, if we look at emergency, the provisions of emergency are contained in Article, one second, in Article 300, in Part 18 of the Indian Constitution, from Article 352 to 360, right? In detail, all the provisions regarding emergency have been discussed in these articles. Now, why emergency? Why these provisions have been incorporated into the Indian Constitution, right? And why has been so emphasis given on these things? Now, imagine a scenario where there is war is declared by India or on India by some external state, right? By some external state. And what will you do in such a scenario? Similarly, like India has fought three big major wars in 1962, in 1965, right, in 1971. Three times India has basically engaged in war, with one time in China and two times with Pakistan, right? And at that time, how would state machinery deal with the issues which are internal, in how internal issues are to be handled, how is legislature to be handled, how is parliament to be handled? Because this is a situation which is extraordinary, which one cannot expect to happen on daily basis. These are some things which happen rarely. Now, in order to prepare for this rare situation, in order to prepare for this untoward situation, in order to prepare for this unexpected situation, the Constitution has provided these provisions. It basically helps the government to deal with abnormal situations effectively. Whatever, as I said, war is an abnormal situation, because normally you don't war with people, right? You don't tell China, "Chaliye ji war khelte hain," right? So normally, there are peaceful conditions, there are peaceful environment prevails between nations. But in case a nation engaged in war with any other nation, like recently we have seen that India and China are engaged in Doklam in Sikkim. Now, God forbids, if both the countries decide that we will have a 1962 type confrontation. In that scenario, what would state do? How will the union government react to it? In order to deal situation like these effectively, the provisions of the emergency have been incorporated into the Constitution. Now, they have been incorporated into Part 18 from Article 352 to 360, which I have already said. Further, during times of emergency, what happens? The central government becomes all powerful, which means that central government assumes the power of the states as well, right? It basically converts a federal structure into unitary one. India is a federal state, right? We have already discussed this. India is a federal state, but during the times of emergency, what happens is that the federal nature of Indian polity gets converted into a unitary one. It gets converted into a unitary one without the formal amendment. Well, the federal structure of Indian Constitution is basically a basic structure, which we have already talked about. It is basic. It is entailed in the basic structure. Now, what happens during national emergency is that this federal structure of India gets converted into unitary one, right? It gets converted into unitary one without any formal amendment. You don't need any amendment to the Constitution, right? It is a unique feature of Indian Constitution, because it has not been found in any other constitution of the world, right? These provisions related to emergency and all these, they were basically collected from different constitutions, but main idea was collected from the German Constitution, right? Like other provisions of the Indian Constitution, this Constitution has also been inspired from the German Constitution. Now, there are three different types of emergency which a state can declare, right? The first one, which is known as national emergency, right? This is known as the national emergency, this one, which is declared under the Article 352. It is known as national emergency. Why is it known as national emergency? Because it prevails in almost all states throughout the country, right? The president basically has got powers to declare it within a specified part or within all area. It is within the discretion of the president. But then it is national emergency because it prevails throughout the state. Most of the states are engaged in it, right? And if emergency is declared due to war, due to external aggression and armed rebellion, right, all these three things can entail to emergency. This is popularly known as national emergency, which we have said already. And the constitution basically employs the proclamation of emergency to denote only this type of emergency, not in case of the state emergency or constitutional emergency और प्रेसिडेंट्स रूल. उस केस में स्टेट जो है या पार्लियामेंट जो है वो नेशनल इमरजेंसी डिक्लेयर नहीं करता है या इमरजेंसी डिक्लेयर नहीं करता, बल्कि इमरजेंसी का मतलब होता है under emergency under article 352. Other two types of emergencies are also there, but then they basically, if we look the frequency or the the abundance of the constitutional emergency or state emergency, it is more as compared to that of the national emergency, because frequently in sometimes within one or two states the this president's rule is declared. So frequency of national this president's rule is greater as compared to that of the national emergency. That is why there is basically what we call the emergency for national purpose or national emergency is the one which is declared under 352, not the one which is declared under 356 or 360, article 360. The second one is that if there is a failure of constitutional machinery, which means what? Which means this is basically a very vague term, because if the directions of the union are not followed by the states, even on that, even for that reason, under 360 article 365, the president's rule can be declared, and even on 356, if they feel that the constitution is not being abided by the state government, or if they feel that there is gross violation of the constitution, if state feels, and they can recommend to the president, and president can then likewise declare constitutional emergency. If they feel that the law and order situation in the state is not right, if they feel that there is basically that the state government doesn't have the numbers to prove, or numbers to basically numbers to pass the confidence test or pass the what we call floor test, they can basically, floor test is later on, but if they feel that the state government doesn't have the adequate majority to prove, the president's rule can be imposed. And for other reasons also president's rule can be imposed. It's not only this thing. Now third thing is that financial emergency can be declared due to threat to financial stability of India, which is what? Which is that if credit of India is in danger, like it was during the year 1991 when there were LPG crisis in India, right? The president could have declared financial emergency, but they didn't declare because they took drastic measures in order to improve the economy of the state, and as a result of which they were able to bypass this particular threat. Now let's talk about national emergency. Under Article 352, President can declare national emergency, right, when the security of India or part of it is threatened by war, or for that matter of fact by external aggression or armed rebellion. So these are the three things which have been given there. One is war, right? One is war, which means that India is at full-fledged war with any other external state. The second thing is external aggression, which means that some external party which has grouped together, right? Say ISIS is a terrorist state. It's a terrorist, Muslim terrorist or Islamic terrorist state, which these are the radicalists. Like if they declare that we are going to, carry out attacks in India, India can, in order to defend itself, declare emergency and then tackle the threat of these radicalized terrorists in a different way. Or for that matter of fact, if armed rebellion takes place inside the Indian territories, like if suppose in recent times Punjab has seen violent protests during 1989, or for that matter of fact Assam, right, northeastern states, Assam, Mizoram, right, Mizoram, Nagaland, in fact all northeastern states, in fact in J&K itself. So if there is an armed rebellion inside, if for that matter of fact, if the insurgency is there in the greater amount, or for that matter of fact, if our own armed forces, they start rebelling against the state, they start rebellion against the state. In that particular case, an emergency can be declared. Recently, we have seen in Turkey. In Turkey, the armed forces had basically rebelled against the state government, prompting the state government to declare emergency. Similarly, in Venezuela, same thing happened. The armed forces basically attacked the president's residence with the helicopters, and they were later on gunned down. But in that particular scenario, also emergency can be declared. So when armed rebellion takes place by the internal what do you call that, by the armed forces itself, then we can term armed rebellion has got different meanings. It could be either your own armed forces, or it could be an organized terrorist attacks, like the one which was done in Mumbai, or for that matter of fact, like the one which was which have been carried out in India in 1993, and similar instances. Now, it may be noted that President can declare national emergency even before its occurrence, even before its actual occurrence, and this provision was basically made by the 38th, amendment. That is, if he satisfied that that there exists a situation where war is imminent, and he can even declare it before the occurrence of the war, right? Now, there are two types of emergency. There is internal and external emergency. The proclamation, the armed rebellion term, as we have said, that it has got wider connotations. It would mean simply that people are armed and they are rebelling against the government, or for that matter of fact, even armed forces, if they rebel against the government, same can be declared as an armed rebellion, right? Now, as we have said, that there could be an internal emergency and an external emergency. Now, if we talk of internal emergency can be basically declared on the grounds of internal disturbance, right? Internal disturbance, which was there in till 1976. This word was replaced in 1976 by what? Armed rebellion, right? This was replaced by armed rebellion, right? Now, for that matter of fact, external emergency simply can be declared or on the grounds of war or external aggression. Now, proclamation of emergency can be applicable to a part of country or to an entire part of it, and this was added through the 44th amendment, and again, the internal disturbance was added as a third ground for proclamation of the national emergency, as we know about it. But the meaning of internal disturbance was too vague and had got wider meanings, and as a result of which the Constitution, through 44th Amendment Act of 1978, substituted the words armed rebellion for internal emergency, right? Now, this internal emergency word was basically misused by the then the only instance of internal emergency is that of 1975, when it was declared on the basis of internal emergencies. There were several reasons, like India had gone on war with basically Pakistan, and later on the financial condition of the country was not good, and as a result of which the country was in debt crisis, and further there was this particular JVP, Vajpayee, Advani, all these were the main basically people who organized it, or who basically revolted against the government of that time, and they were sent behind the bars, and the emergency was in operation nearly for 21 months, right? And from 1975 to 77, right? But this provision has now been struck down. There is no possibility of declaring emergency on internal grounds now, or internal disturbance, though internal and external emergency is there. But the internal and external emergency simply means, internal means that you are declaring it on the basis of armed rebellion which takes place inside the country, and external means, right, external means that on war or external aggression, which is an extra territory entity declares war against India, or declares attack against India. In that particular scenario only, you can basically declare national emergency, right? Now, talking about that, can president declare emergency on his own? No, president cannot basically declare emergency on his own. He has got no discretionary powers. He can proclaim a national emergency only after he has got, received a written request from the cabinet, recommendation from the cabinet. This means that even if Prime Minister himself says that, even if only like if our PM direct his president to declare emergency on his own, right? There is no concurrence from the cabinet. He cannot declare it, right? He cannot declare it. He cannot declare it unless and until there is no concurrence of, unless and until there is concurrence of the cabinet, that is, cabinet is of the same view as that of the PM, then only an emergency can be proclaimed. So it becomes very important that the proclamation of the emergency happens only after the cabinet has recommended to the president that, okay, go ahead, declare emergency. In 1975, the then Prime Minister Indira Gandhi, she had basically advised the then President Zail Singh to proclaim emergency without consulting her cabinet, right? Now, they were informed later on. The 44th Amendment Act of 1978 introduced this safeguard to basically eliminate any possibility of Prime Minister alone taking decision on his own. So neither Prime Minister can take his decision on own, neither Prime Minister, ना ही तो प्राइम मिनिस्टर अपने आप से डिसीजन ले सकता है, nor president can declare emergency on his own. That is, they cannot declare emergency on their own behalf, right? They have to take consultation, or they have to seek recommendations of both cabinet as well as prime minister, and then only concurrence of cabinet is necessary, right? Prime minister alone cannot give or issue directions to the president to declare emergency. The 38th Amendment Act of 1975 made this declaration of national emergency immune from judicial review, but then later on in Minerva Mills case, it was held that the emergency can be challenged on the ground of being malified or perverse or wholly on extraneous and irrelevant facts. So this means that the national emergency is not free from judicial review. That is, judicial review will take place. National emergency not free from judicial review. That is, okay, that national emergency can basically be challenged in the court on the ground of being malified, or that if it was based on extraneous or irrelevant phases, and they can basically struck down the national emergency. The court can struck down the national emergency. Now, proclamation of the national emergency, it must be approved by both houses within 1 month of its date. Originally, it was 2 months, but later on, by the 44th Amendment of 1978, it was reduced to, originally it was 2 months. 2 months के अंदर पार्लियामेंट को अप्रूव करना पड़ता था इमरजेंसी को. फिर later on it was reduced to 1 month by 44th Amendment Act of 1978. Now these amendment acts are being asked by the UPSC recently. They have asked through which amendment act was the workers' participation management introduced as a direct to state principal policy. Now you should remember these particular acts, that what was brought through what act. Now, in case of dissolution of Lok Sabha without the approval or without the approval of the proclamation of the emergency, that is, the resolution is to be taken 1 month after new Lok Sabha is reconstituted, which means essentially that after 7 months, if the Lok Sabha has been dissolved, or if for any other matter of fact that Lok Sabha has been dissolved, or Lok Sabha is the new Lok Sabha. 6 months is for that of the elections, because before 6 months election is to be and then plus 1 month for the approval. So it will technically take 7 months to get it approved in case Lok Sabha is being dissolved. Now, if approved by both the houses, the emergency continues for 6 months, right? It continues for 6 months, and it can be extended for an indefinite period, right? So इसमें कोई बार नहीं, अपर बार नहीं, जैसे कि for President's rule the maximum time frame is 3 years. यहाँ पर कोई रूल ऐसा नहीं है कि आप indefinitely इसको impose कर सकते हो, provided that you approve it after every 6 months, right? Now, resolution approving the continuance must be in fact passed by the majority. This was again introduced by the 44th Amendment Act of 1978. Previously, this was passed by the simple majority. So 44th Amendment has basically brought 44th Amendment has brought a lot of changes, especially related to the provisions of the emergency, right? Now, moving on and talking about the revocation of the proclamation of the emergency. A proclamation of emergency may be revoked by the president at any time by a subsequent proclamation, right? He issues proclamation, and his proclamation this time doesn't require any parliamentary approval. In order to proclaim emergency, he requires parliamentary approval, but in order to revoke, he doesn't require any parliamentary approval. Lok Sabha passed a resolution disapproving its discontinuation, and then there is same amendment for it, which was the 44th Amendment Act of 1978. Now, if 1/10 of the members give a written notice to the Speaker or to the President, a special sitting within 14 days is to be considered for the disapproval or for the revocation of the emergency. There is difference between the two. That is, there is difference between the proclamation which talks about imposition of emergency and which talks of revocation of the emergency. In the first case, that is in case of a proclamation which talks about the imposition of the emergency, it has to be passed or introduced into the Lok Sabha and passed by a special majority in the Lok Sabha, right? What is the difference between the resolution of approval and disapproval? Now, the resolution of approval, right? Resolution of approval requires to be passed in both houses by special majority, right? And resolution for disapproval needs to be passed in Lok Sabha only, and that too with simple majority. Like, this is the difference between both of them. Fine. Now, moving on and talking about what are the effects of the national emergency. Now, effects of national emergency can be basically discussed in terms of what is their effect on the central-state relations, what is their effect on the लाइफ ऑफ लोकसभा. लाइक हम तीन मेन चीजों पे इसके ऊपर डिस्कस करेंगे. एक तो इसका इफेक्ट क्या होता है ऑन सेंटर स्टेट रिलेशंस. देन विल टॉक अबाउट द इमरजेंसी प्रोविजंस के ऊपर इसका क्या इफेक्ट पड़ता है. What is its effect on the emergency provisions, and what's its effect on the, what was the third thing, on the life of Lok Sabha. So we will look it from these three particular things. The first thing is the effect on the center state relations. Now, effect on center state relations, as we have already said, during the national emergency, the center becomes all powerful. It converts a federal structure into a unitary one without any formal amendment. But the main question here is that the state legislature is not suspended, right? It is suspended in what case, or it is dissolved in what case? It is suspended or dissolved in case of the president's rule, not here. Here, the state legislature or state executive, they continue to function, right? They continue to, they are there in existence, but they are there, but they are under the control of the center. They have to function as center decides to function for them. Now, during national emergency, the parliament becomes empowered to make laws on any subject which is even mentioned in the state list. Now, state list, we know for state list only states can make laws, but during the national emergency, even state list, the union legislates. Now, these laws made by the parliament on the state subjects during the national emergency are to become inoperative after 6 months of the national emergency ceases to exist, right? And another thing is that ordinances can be issued by the state if parliament is not in session in time of emergency, right? So suppose if parliament is not in session, president can issue ordinances on the state matters, right? This is very important. On the matters of the state, president can issue ordinances. This is what happens to the powers of the state legislature and executive during the emergency, right? Executive continues to exist, they continue to exist, but they become or they are being controlled by the center, right? They are not suspended. Similarly, legislature continues to exist, but the power to make laws is rested with the Parliament. That is, the state list is overtaken or overridden by the parliamentary laws. Similarly, the president can issue ordinances on the state subject. Now, 42nd Amendment Act of 1976 provided that the two consequences which have been mentioned above, that's executive and legislative, it exists not only to a state where emergency is in operation, but to any other state also, right? Now, what are the financial? What happens to the finance? Now, we talked about legislature, we talked about the executive, we talked about legislature, we talked about executive. Now, what happens to financial conditions? The finances can be curtailed by the center. Like if some state was getting, say, 1,000 million rupees as a grant for particular fiscal, they might cut down it to 10 million only. So this is at the discretion. They again are at the discretion, or nobody can challenge it. Nobody can challenge them that why you have done this, why you have done that, right? This means that president can either reduce or cancel the transfer of finances to the center. The modification continues till the end of the financial year when the emergency is in operation. And also every such order means that an order which refers to curtailment of the finances of the state needs not to be approved by the both houses of the parliament, needs not to be laid before the both houses of the parliament. Now, what happens to the Lok Sabha and State Assembly? Now, while a proclamation of national emergency is in operation, the life of the Lok Sabha can be extended, as we have said, beyond its normal term indefinitely, but then it has to be approved, right? It has to be approved periodically after 6 months. And this extension cannot continue beyond a period of 6 months after emergency ceases to operate, right? So fifth Lok Sabha was basically extended from it was to conclude at, say, 1975, but it was extended 2 times by a year at a time. Similarly, the parliament may extend the normal tenure of the legislative assembly by 1 year each time for any length of time during the national emergency. So it is for both cases. They can be, Lok Sabha can be extended indefinitely, and similarly state can be extended indefinitely. Both of them can be extended indefinitely, but then there is to be a periodic approval which is required, which is necessary for them to prove their legitimacy. Now, what happens to the fundamental rights under Article 19? Now, first up, the fundamental rights, all fundamental rights are being basically, curtailed during the national emergency, except 20 and 21, right? 20 or 21, Article 21 or 20 or 21 को छोड़ के जितने सारे fundamental rights है वो सारे के सारे जो है वो curtail किए जाते हैं, वो curb किए जाते हैं. Now, there are 2 articles which deal with them. One is 358 and another is 359. We will talk about the differences between the two a bit later. But here, according to Article 358, when a proclamation of national emergency is made, the 6 fundamental rights are the 6 fundamental rights which are there under the Article 19 are automatically suspended. That's the freedom of speech and expression, freedom of association, freedom of assembly, right? Then freedom of movement, then freedom of residence, right? Then freedom of profession. All these basically all these freedoms, the 6 freedoms under Article 19 are curtailed by Article 358, which deals with the curtailment of this particular provision. And when proclamation of national emergency is in operation, the state is freed from restrictions which are imposed by that is, they can do anything, whatever they want to do. Nobody can question them that why you are doing this thing, why you are doing that thing, why you are taking our freedom of speech and expression, why you are not allowing us to move towards the different areas. All these actions are taken, and all these are legally and constitutionally correct under Article 358. In other words, the state can make any law which can take executive action abridging or taking away 6 of the fundamental rights which are guaranteed by the Article 19. And any law or executive action cannot be challenged on the ground that they are inconsistent with the fundamental. So you cannot invoke 332, Article 32, or for that matter of fact, Article 226, which deal with the declaring that any law which is in contravention with that of the fundamental rights has to be struck down. You cannot do that, right? You cannot do that because if Article 358 is there, if Article 352 has been imposed, then under Article 358, all these impositions, all these the fundamental rights will be curbed, or they will be basically restricted. Now, when the national emergency ceases to operate, Article 19 automatically revives and it comes into force, right? Any law which is made during the emergency, well, you cannot question that. Whatever it did in the Article 19, you cannot question it. However, no remedy lies in anything done during the national emergency or anything after emergency expires. This means that legislative and executive actions taken during the national emergency cannot be challenged on the ground that they were violative of the fundamental rights. The 44th Amendment Act of 1978 has restricted the scope of Article 358 in two ways. Now, there are two ways through which it has restricted the scope. First, Article 19 comes into being only when there is emergency on external aggression or on war. The second thing is that those laws which are related with the emergency are protected from being challenged, and not any other law. Like there is law related to religious minorities, protection of the cultural rights. You cannot challenge them, or you cannot basically curtail them. Only those laws which are related to the emergency are to be protected, not any other law. Also, the executive action taken under such law is protected. Now, what about the suspension of other fundamental rights? The suspension, Article 359 basically authorizes President to suspend the right to move to any court for their enforcement. That is what I said, that under Article 358, 359, the rights are there. That's all rights are there. But you cannot go to the court for their imposition. Like, you cannot go to court and tell them impose Article 226 or 32, right? Supreme Court को आप जाएंगे और आप बोलेंगे आर्टिकल 32 को इन्वोक करो, या हाई कोर्ट को जाएंगे 226 को इन्वोक करो. They cannot, because its imposition or its enforcement has been already deactivated by Article 359. Article 359 says simply that you cannot move to the court, right? You cannot move to the court and you can seek remedy for the violation of the rights. You cannot go to the court because it has already been inactivated by 359, right? This is simple crux of the 359, right? The fundamental rights are not suspended, but their enforcement has been suspended. So theoretically they are alive, but the right to seek remedy is simply suspended. Simple सी बात ये होता है in case of Article 359. Now, when the order ceases to operate, any law so made to the extent of inconsistency with the specified fundamental rights ceases to have effect, but no remedy lies for anything done during the operation of the order, even if it ceases to operate, right? Now, the 44th Amendment Act of 1978 has basically restricted the scope of 359 in two ways. Firstly, Article 20 and 21, that is right to a right to protection in respect of Convention for Offences, Article 20, and a right to life and personal liberty. These cannot be curtailed, or you can simply say that during national emergency, only two fundamental rights are there which are alive, that is Article 20 and 21, right? All other fundamental rights like Article 19 को तो curtail ही किया जाता है, वो तो उसको खत्म ही कर दिया जाता है, but other articles which is like 13, 14, 12, right, 15, 16, 17, 18, ठीक है, 20 और 21, तो मतलब ये अलाइव होते हैं. बाकी इनके अलावा जितने भी एक्ट्स होते हैं, जितने भी हमारे पास फंडामेंटल राइट्स हैं, वो सब के सब जो है उनकी एनफोर्समेंट को डीएक्टिवेट किया जाता है, वो थ्योरेटिकली अलाइव होते हैं. लेकिन दो तरीके की रिस्ट्रिक्शंस है जो कि मतलब आप 20 और 21 को सस्पेंड नहीं कर सकते हो, और सिर्फ वो लॉ होते हैं जो इमरजेंसी से रिलेटेड होते हैं, आप उन्हीं को सिर्फ प्रोटेक्ट कर सकते हो, बाकी लॉज को चैलेंज किया जा सकता है. Now let's talk about another very important which is very important aspect, that is the difference between let's talk about the हम यहाँ पर सीधे करेंगे difference between 358 and 359. Now when we talk about Article 358, under Article 358, Article 19 is suspended, right? अब आर्टिकल 359 की जब बात करते हैं तो अंडर आर्टिकल 359 the enforcement of or right to seek remedy is suspended. That is, you cannot go to the courts and tell them under Article 32 and Article 226 you have to issue writs of habeas corpus mandamus quo warranto certiorari in order to implement these rights. You cannot go to the court and tell them about this thing. This is the first thing. The other thing which is difference between now let's talk about what is difference between Article 358 and 359. Under Article 358, as we have already said, it extends to Article 19 only. 359 extends to all of the other articles which are there. That is so Article 358 basically automatically suspends the fundamental rights under Article 19, and Article 359 suspends the enforcement of the that is right to seek remedy. And 358 is basically implemented in case of the external emergency, and 359 is implemented in case of internal as well as external emergency. Similarly, 358 suspends the Article 19 during the entire emergency period, while as the 359 suspends other rights, but for a specified period of time within which, as President suggests. Now 358 basically is implemented to whole country, right? 359 might be implemented to a part of it, and 358 suspends the whole of the Article 19, and 359 doesn't suspend 20 and Article 21. Now moving on and talking about how many times declarations have been made. 3 times so far, in 1962, 1971. On these 2 times it was done on the grounds of war, right? And in 1975 it was done on the grounds of internal disturbance, right? So this is how many times the proclamations have been made, and during 1975 the ground which was suggested by the government of that time for implementing the emergency was that there was some sort of forces were trying to incite the police and armed forces against the discharge of their duties and normal functioning. This is what the reason was stated. Now let's talk about the President's Rule and Article 356. Article 355 imposes a duty on center to ensure that the government of every state is carried on in accordance with the provisions of the Constitution. Now it's a duty of the state, or it is this duty in performance of which center takes over the state government under Article 356 in case they feel that the government of the state is not being run as for the as far as the provisions of the Constitution is concerned. And this is also known as the President's Rule, is known by other names also, like State Emergency or President's Rule, or for that matter of fact it's also known as Constitutional Emergency. In J&K there is Governor's Rule and President's Rule, because Governor's Rule will be implemented under the Constitution of the J&K and President's Rule under the Constitution of India. Now the President's of Rule can be proclaimed under Article 356 on 2 grounds. There are 2 grounds for President's Rule. One is that they are not functioning as per the constitutional machinery. The other is mentioned in the Article 365, right? Article 365 says that whenever a state fails to comply with or give effect to any direction from center, it will be lawful for the President to hold that the situation has arisen in which the state government cannot be carried out in accordance with the provisions of the Constitution. So there are 2 things: if you do not follow the Constitution, or if you do not follow the there are 2 things here to be mentioned. One second. There are 2 things which we have to take care of. One is 356 and 365. Article 365 simply talks about few things, which that if center tells state to say implement a particular thing, and if state fails to do so, or if state deliberately doesn't do it, then if the center is basically, the state is violating the instructions of the center, on that ground, that is 365, the president's rule can be. So we have already said that the president's rule can be declared on two grounds. That's Article 356. That is, if the center feels that there is failure of constitutional machinery in the state, they can ask the president to impose his rule in the state. And similarly, under Article 365, if the directions of the center are not being carried out as per their wishes, then again under Article 365, the president's rule can be imposed. Now, the proclamation imposing the president's rule, it must be approved by both the houses of the parliament within the 2 months of its issue. Now, in case of the state emergency, it was 1 month, right? In case of the president's rule, it is 2 months, right? However, if proclamation of the president's rule is issued at the time when Lok Sabha is not in power, or Lok Sabha has been dissolved, then, as we have already said, that the 6 months gap between the two elections plus 1 month for its approval, right? Or 2 months for its approval. That is, a maximum of 8 months is required for the approval of the president's rule. So, if approved by both houses of the parliament, the president's rule continues for 6 months, and it can be extended for a maximum period of 3 years within its approval after every 6 months, right? So, the national emergency, it can be basically, national emergency can continue for an indefinite period of time, but for president's rule, it can continue after a maximum of the 3 years, right? Now, if 1 second. Now, every resolution approving the proclamation of the president's rule or its continuation can be passed by either house of the parliament by a simple majority. Special majority is required in case you want to basically pass the national emergency. In that case, you require special majority, while in case of the president's rule, you require only simple majority. Fine. Now, the 44th Amendment Act of 1978 has introduced a new provision to put restraint on the power of Parliament to extend the proclamation of the President rule beyond 1 year. Thus, it's provided that beyond 1 year, the President's rule can be extended by 6 months at a time, only when two conditions are fulfilled. That is, a proclamation of national emergency should be in operation in whole or in any part of the India, and Election Commission must certify that general election to the legislative assembly of the concerned state cannot be held because there are difficulties that they are encountering, right? A proclamation of the president's rule may be revoked by the president at any time, and you do not require a subsequent proclamation for it. Such a proclamation by a subsequent proclamation, but it does not require parliamentary approval like it requires approval for the other proclamation. Now, what happens during the president's rule? The first thing that happens during president's rule is that the executive and the functions of the state government and the powers are vested. All executive as well as legislative functions, they are vested with the state governor. He can declare that the powers of the state legislature are to be exercised by the parliament. He can take any other necessary steps, including suspension of the constitutional provisions relating anybody or authority in the state. Right? When the president's rule is imposed in the state, the president dismisses the state council of ministers as well as chief minister. Right? The state governor on behalf of the president carries on state administration with the help of the chief secretary of the state or the advisors which are appointed by the president. That is why this is known as the president's rule. Now, the parliament either suspends or dissolves the state legislative assembly, and the parliament passes a state legislative bills as well as state budget. So it's parliament who passes both state legislative bills as well as budget. And when the legislature is suspended or dissolved, the parliament can basically delegate the power to make laws for the state to president or to any authority which are specified. So they can give it to the president or to any other further authority which they desire. The parliament, or in case of delegation, the president or any other specified authority can make laws conferring the powers and imposing duties on the center or its officers and authorities. President can authorize, when the Lok Sabha is not in session, expenditure from the state's consolidated fund pending the sanction by the parliament, but it is required sanction by the parliament. President cannot do it on its own discretion. The funds, if they are required by the state, they can do but then it requires parliamentary approval, and the president can promulgate, when the parliament is not in session, ordinances for the governance of the state, right? Now there are cases of proper and improper use. Yeah, the following are the situation where it is proper to use the president's rule: when after general assembly elections no party secures a majority, right? No party secures majority, then president's rule can be imposed. Where the party having a majority in the assembly declines to form ministry, or and the governor cannot find the coalition. So if somebody has won the elections and they are not willing to form the government, they say we are not willing to form the government, and there is no coalition which governor finds feasible to lead the assembly, in that particular case also president's rule is imposed. Where a ministry resigns after its defeat in assembly and no other party is willing or able to form a ministry commanding a majority in the assembly. Where a constitutional direction of the central government is disregarded by the state government. Internal subversion, where for example, a government is deliberately acting against the constitution and law and is fomenting a violent revolt, where state government is up in arms against the union government. Physical breakdown, where government willfully refuses to discharge any of the constitutional duties or obligations which are given to the state, right? Further, the imposition of the president's rule in the state would be improper under the following conditions: when where a ministry resigns or is dismissed on losing the majority of the support in assembly, and governor recommends the imposition of the president's rule without probing possibility of forming the alternative ministry, where the governor makes his own assessment of the support of ministry in assembly and recommends imposition of the president's rule without allowing the ministry to prove, मतलब कोई फ्लोर टेस्ट नहीं, कुछ नहीं, आप सीधे उनको मतलब भगा देते हो, राइट? इट हैपेंड इन उत्तराखंड केस, ठीक है? उत्तराखंड केस में यही हुआ था कि वहाँ की जो गवर्नमेंट है उसको प्रेसिडेंट ने डिसमिस किया था विदाउट approving their floor test, and then Supreme Court later on said that the floor test must be conducted and the manner in which the government was dismissed was unconstitutional. Where the ruling party enjoying majority support in the assembly has suffered a massive defeat in the general elections to the Lok Sabha, such as in 1977 and 1980. Internal disturbances not amounting to internal subversion or physical breakdown, right? Cases of improper में फिर और आता है maladministration in the state or allegations of corruption against the state or stringent financial exigency in the state, where the state government is not given a prior warning to rectify itself except in case of extreme urgency leading to disastrous consequences, where the power is used as a sort of intra-party problems of the ruling party or for the purpose of extraneous irrelevant to the constitution has been conferred by the constitution. Now, what are the grounds of declaration of the financial emergency? Financial emergency is declared on the basis of Article 360. The president proclaims a financial emergency. It is satisfied that the position of the finances in the India is such that the credit and stability of the part of India or its territory is threatened. The 38th Amendment of 1975 made the satisfaction of the president declaring the financial emergency final, conclusive, not questionable in any court of law on any ground, but this provision was subsequently deleted by the 44th Amendment Act of 1978, implying that the satisfaction of the president is not beyond the judicial review. Judicial review is very important, right? A proclamation declaring financial emergency must be approved by the both houses of the parliament within 2 months from the date of issue. However, if the proclamation of the financial emergency is issued by the Lok Sabha at a time when the Lok Sabha, is not issued at the time when the Lok Sabha is not in session or is to be dissolved or the term has expired, then again it is 6 plus 2, that is 8. 8 months की गैप के बाद उसको कंप्लीट करना है, या उससे पहले भी हो सकता है. It could be that elections take place before 6 months, that is within the 4 months, within the 5 months, within the 2 months. So plus 2 within 4 months, within, but not beyond the, like it could not be 7 plus 2, right? It could not be 9 months because you cannot go beyond 6 months as far as election is concerned. So once approved by the both houses of the parliament, the finances, the financial, it is to be approved by the simple majority. There is no special majority which is required for it. Once approved by the both houses of the parliament, the financial emergency continues indefinitely until it's invoked. So it's not like 3 months, 3 years in case of the constitutional emergency. It's not like this. It remains in operation till indefinitely, and it doesn't require repeated parliamentary approval like in other two cases जहाँ पर कि 6 months के बाद हमें अप्रूवल की जरूरत होती थी. यहाँ पर ऐसा कुछ है नहीं, अप्रूवल नहीं भी होगा तो भी चलेगा. So a resolution approving the proclamation of the financial emergency can be passed by either house of the parliament only by simple majority, that's majority of the members. So you require special majority only in case of the national emergency, right? Not in case of constitutional emergency or financial emergency. A proclamation of the financial emergency may be revoked by the president at any time by a subsequent proclamation. Such a proclamation does not require the parliamentary approval, right? What happens during the financial emergency? The first thing is that the executive authority of the center extends the directing any state to observe such canons of the financial propriety, right, as are specified by it, and the president as directions as the president may deem necessary for the adequate purpose. तो वहां पर मतलब जो रिडक्शन सैलरीज में किया जा सकता है, ठीक है, अलाउंसेस, पेंशंस, रिजर्वेशन ऑफ ऑल मनी बिल्स एंड अदर फाइनेंशियल बिल्स फॉर द कंसिडरेशन ऑफ द प्रेसिडेंट. ये स्टेट्स के बारे में हम बात करते हैं क्योंकि सेंटर में तो वो होता ही है. तो प्रेसिडेंट में इशू डायरेक्शंस टू रिडक्शन ऑफ सैलरीज, अलाउंसेस एंड ऑल अदर मतलब सैलरीज, अलाउंसेस, फाइनेंसेस, टोटल फाइनेंसेस कट किए जाते हैं ताकि फाइनेंशियल सिचुएशन जो है, क्रेडिट जो है वो मेंटेन किया जाए. ड्यूरिंग द ऑपरेशन ऑफ द फाइनेंशियल इमरजेंसी सेंटर जो है फाइनेंशियल मैटर्स पे स्टेट्स के ऊपर कंट्रोल हासिल कर लेता है. एंड नो फाइनेंशियल इमरजेंसी हैज बीन डिक्लेयर्ड सो फार, though there was financial crisis in 1951, but financial emergency was not declared. Now, which of the following is true? Part 20 of the Indian Constitution deals with the emergency provisions, and an emergency converts a federal structure into a unitary one without a formal amendment of the Constitution. I believe only 2 is because 18 deals with the provisions of the this, right? So only 2 is correct. Similarly, in which of the following situations the use of president's tool is allowed? Maladministration in the state or allegations of the corruption against the ministry or stringent financial exigencies of the state. Hung assembly के केस में होता है, and the constitutional direction. So it is certainly only 2 and 3 because this one is the case improper. We have discussed it among the case improper. ये नहीं हो सकता है. तो further, which of the following is true? Critics claim that emergency provisions undermine the fundamental rights, which is true. President becomes the dictator by the emergency provisions as per the critics. The president तो नहीं बनता है, but the state government does become the dictator. So we can say that first one is true. So that's all for today's lecture. I hope that this lecture has been fruitful to you. Thank you very much for joining me. We'll discuss other topics in the coming lectures. Thank you very much.